Good morning, and welcome to Thompson Hine's weekly coffee chat series. My name is Mark Miner, and I'm a senior counsel in Thompson Hine's investment management practice group. Delighted that joining me today is Dina Tantra, who is an attorney, experienced executive, independent board member, raconteur. There's so many things. We're so excited to have her participating today. Dina thrives as a board member. She's serving as an independent board trustee for an SEC registered investment company, as well as a board member for a private fintech. She leverages nearly 30 years of experience in asset management to set strategic direction, enhance revenue growth, and navigate governance, regulation, and risk. Today, we will discuss Nasdaq's SEC approved now board diversity rule, which requires companies that are listed on its U.S. exchange to address the issues of board diversity. This progressive rule imposes new requirements on most Nasdaq-listed companies to have eventually at least 2 diverse directors, including one who self-identifies as female and one who self-identifies as either an underrepresented community member or LGBTQ, or importantly, to simply explain why they have not done so. If you have questions or comments during our presentation, you will see that there's a chat feature. We encourage you to put those questions or comments in the chat. As interesting questions pop up, we may just jump in and pepper Dina with those questions as we go along and try to answer them, try to keep things conversational. So with that, let's get started. How are you, Dina?
Great. Thanks, Mark. Pleased to be here. Thrilled that you and Thompson Hine are continuing to keep this topic at the forefront. I think having these conversations not only leads to education, but action. And so thrilled to be a part of this.
Well, that's a good way to tee up the beginning of the conversation. There's been lots of chatter, as most folks know. In December of 2020, Nasdaq proposed this rule, which they have stated in the rule proposal. It states that their intention was to encourage addressing diversity disparities at the board level through greater transparency about board diversity considerations for those listed companies, and urging them to report the statistics and their success in trying to do so. It was the hope that this exercise would then lead to a greater board diversity, or to report their rationale for not doing so. And seemingly this is an exercise that they thought would be useful, and we'll talk a little bit more about the materiality that the report suggests the adopted rule believes is one that a reasonable investor would want to consider in its decision to invest or not invest.
And I think, Mark, you and I talked about this. It kind of hits it at a couple of points. The disclosure obviously is intended to allow investors to make informed decisions, right? And so they have the information. They can compare sort of in an apples to apples fashion what makes sense for them, and they can take action with respect to their buys and sells. I was in a conversation yesterday where there was a question about, is this really a platform for public shaming, if you will? And I'm not sure it goes so far. I mean, it's disclosure, so people can say what they are doing. If they're ashamed of what they're doing, then maybe they should change their tune. But it's really just sort of highlighting what position they've taken. And maybe it is an opportunity for an effective nudge, if you will, into taking action rather than staying silent. But I don't think it's intended to shame anyone. It's just sort of raise the awareness of practices.
No, I think that's an excellent point in this question of whether or not it becomes a forum or an opportunity for public shaming. Those who have followed this, as I know we have, know that it produced almost a record number of comments in the period of consideration. And the proposal itself was voluminous, much longer than many, almost 270 pages. And in that, they went through, great lengths to discuss various viewpoints. And there are many market participants who offered their commentary, believing that this was both unnecessary and in some cases unconstitutional. But to your point, those institutions are free, as far as I understand the rule, to list in the annual description what their efforts have been, and if their efforts have been little or none because they don't believe that it has that particular value, or this is some exercise in shaming, I suppose they're free to do that. We'll talk a little bit about the form that's been approved, so people don't have to guess about how you report. I just want to move on with a few buckets so folks that are not steeped in this understand what the definitions are. So if you are a company that is listed, or you're considering to be listed, or you just want to know and understand what the obligations are here, the definitions from the approved rule of diverse is any individual self-identifies as female, underrepresented minority, or LGBTQ plus. This self-identification becomes important because neither of us are labor and employment lawyers, but there are some restrictions about what you can ask individuals, both when you're considering someone for a position, and then some requirements to have demographic information about who works for you.
Yeah, and Mark, when we get more into the meat of our conversation, I want to talk about that self-identification, because I do think that's an action people searching for board positions can do. They can figure out ways to self-identify, to share that information with others, so it isn't hidden somewhere. But it's sort of a new world for us because it's not necessarily something candidates put on their bios or resumes or embed in their emails. But if you are self-identifying, let's talk about that a little bit later.
Sure. So the same goes for self-identifying in terms of gender. This rule is without regard to the individual's designated sex at birth. LGBTQ also self-identified. Underrepresented. I've had a few of these questions. What fits in the bucket? How it differs from some other Department of Labor characteristics, but they try to marry as close as they can. And the categories include Black or African American, Hispanic, Latinx, Asian, Native American, Alaska Native, Native Hawaiian, Pacific Islander, or any two or more races or ethnicities. And an increasing portions of America would self-identify as multicultural or other. And here again, if you self-identify, you could put yourself into that category. You've been so identified to the institution. Companies are not required to include, a check-all box. And the rule is not intended to require the company to change the way that it characterizes employees at the institution. So you don't have to impose a self-identification or not. So that's an important note, I think, in the final rule. So really quickly, how will this roll out? If you are a company that is listed and you want to know what the timetable is, the progression is year one, you'd be required to report diversity statistics within 1 year of the rule implementation. Within 2 years, to begin to address at least one diverse director, or to just simply provide the explanation. Within 4 years, to move towards 2 of those directors. There's some limitations on that for U.S. Institutions versus some global, and the rules related to that are kind of buried deep in the rule. I don't want to get too much into it now, but for the overwhelming majority of institutions, that would be the classification. As we talked a little bit about how the information and should be reported to the institutions, the example for providing the rule, although it's not prescriptive in any way, is a matrix. And the matrix contains the categories and the information that NASDAQ would expect to see in the report and was adopted by the SEC in the rule. I don't know if you have any thoughts about whether or not it would be smart or useful to use that as the rubric for reporting, or if you've heard from any institutions who have even yet begun to think about whether or not there might be a rationale to not use it.
Sure. Not specifically to that point, but yesterday I was in a conversation with, as you can imagine, other lawyers. And the conversation was more about, well, if this is a NASDAQ rule, where are we heading with open-end funds in the SEC? And some people were suggesting that perhaps this would be optional disclosure to add to the SAI in an open-end fund space. And then there were other people saying, well, if it's not legally required, maybe err on not disclosing, because we only like to put things that are legally required into legal documents. And so there was that kind of debate. Because the SEC doesn't have a similar framework, it's not as easy as just put the grid in. You know, are you talking about text? Are you putting tables or whatever? So the conversation, when it's not a black and white requirement, I think does kind of delve in that gray area of, do you add it because you think it provides value, or are you now running the risk of over disclosing and providing fodder for other types of legal action?
You know, like, I certainly want to get into kind of the second half and meaty part of this conversation, which is how these institutions and individuals should be addressing the role when the rubber meets the road. But this is fascinating, so I kind of want to go down this rabbit hole a little bit about value. Those who are watching the market kind of generally are seeing that with ESG and other similar efforts that are you know, kind of converging with some of the prescriptive rules, that there is a heightened interest in what a reasonable investor might want to consider. And so I think the reflex of most lawyers would be, is it required? And what is the risk of including any word that's not absolutely required? But they would be required to think about this in terms of drafting, in terms of what is material, right? And when you're thinking about materiality, it's a bit of a different test. Value to me is the value proposition, the goodwill of an institution, and all those things. They might also meet the definition of material. And remember, for those of you out there who aren't in this every day, something is material if a reasonable investor would find it important in the total mix of information that investor might have to make a decision to invest or not invest. It need not be determinative. And so these ESG efforts, including the SEC last year appointing as our over all of these issues, is suggesting that for some of these environmental and social factors, that investors want to have this level of transparency. So as institutions are out there trying to figure out what the value proposition is of adding something, we obviously don't want it lost that things that are material would have to be disclosed. And then there are many institutions that have already raised their hand. Northern Trust has been in the public talking about this a lot, about how they are leading with this because it's important to their DNA. So just two last quick things about the rule, and we can kind of shift on to some other topics. So a issuer, if one were to violate the rule, technically not provide the required information or report, would have 180 days to cure if they were sent a notification that the appropriate information was not received, or they received a report but the report was incomplete. And simply explaining, well, not simply, but explaining why in that report that there was not a timely submission would satisfy the rule. As Dina was alluding to, importantly, there are several companies who would be excluded from this rule. Certain acquisition companies, asset-backed insurers, co-ops, management investment companies, issuers that are voting non-preferred securities. There's a whole series under Nasdaq Rule 5700 that I would encourage you to visit if you're not sure if you would fit. And so the final rule was implemented in August of 2021, so we would be looking to August of 2022. What's been really fascinating to me is all the ways in which Nasdaq was trying to distinguish its rule from the California rule, which has a similar objective but has a board mandate. And so that was met pretty quickly with some legal challenges for constitutionality of requiring boards to have members of underrepresented communities or women, etc., on its boards. I mean, who knows where that is going to go? And Nasdaq very intentionally had its rule simply to require reporting of its statistics as opposed to a mandate. And yet, there have been two challenges to the rule. The SEC was already sued after implementation of the rule in the Third Circuit Court of Appeals. This rule allows institutions that believe they are affected to bring an action challenging the authority of the administrative agency, or the agency, in this case, the SEC, in the jurisdiction in which they reside. And so the first challenge came from the Third Circuit, and we're waiting to see what has happened with that. There was a second challenge mounted in the Fifth District, and the allegations are largely the same. There was a request to consolidate those two cases so they can be heard all at once, since the arguments are ostensibly similar. So we'll see how that how the court responds to that. For those who aren't aware, the person who filed this rule challenge is also related in some way to the organization that filed the Fifth Circuit challenge. And interestingly, is a longstanding opponent of really any type of affirmative action, and has in years past challenged Harvard's admission policies as reverse discrimination. So there are people that are long steeped in challenging some of these notions, and we'll see where that goes. So now let's get into some of the reasons why Nasdaq even proposed this rule, and some of the practical ways that institutions can look toward addressing issues of board diversity, the value of board diversity for those who believe in it. The adopted rule had extensive research that it discussed to talk about both the U.S.'s place in this particular marketplace, and our track record in having diverse boards. So there's research to suggest that having diverse boards brings in thoughts and ideas that create a better outcome, or specifically for Nasdaq listed companies, even is outperforming other institutions. In terms of just board diversity overall, I was surprised to find that the U.S. lags far behind other parts of the world. I think the rule said, the adopted rule said that we in the U.S. ranked 53rd. So I don't know what you are seeing domestically or globally, whether the U.S. is keeping pace or efforts to change in that area.
Yeah, I've definitely seen various statistics. One that came out in a industry conference over the last couple of weeks highlighted a concept about women in the interview process. And if there is only one woman in the interview process in the pool of all the qualified candidates, she is not likely to be selected because she is the only woman in the pool. If there is more than one woman in the pool, the chances of selecting a woman increases, I think, by 60%. It's crazy. And obviously, if there's more women in the pool, you have more to choose from. But I do think they were commenting on the dynamic of if there is only one, the board may veer away from selecting an only, because that person sort of stands out as being different. And so I think that these types of rules and these types of conversations start to change who is in the candidate pool and levels the playing field. You know, you still want the most qualified candidates and you still want to select the best people for your particular board. But I think the key is to level the playing field. To get people into the pool is so very important.
Right. I mean, that's a fascinating idea about maybe even the psychology of how boards tend to choose. And, you know, even something as simple as numerosity can help affect that.
Right.
So, you know, lest we're just giving a context to what numbers we're talking about, by any measure, at least the final adopted rule considered the number of women on these boards to be meager. Certainly in proportion, not only are they half of society, but even as far as to the extent that they're represented in business and in these institutions and having this expertise, and underrepresented minorities even more so. You know, so we're talking, I think, over the past 10 or 15 years, the study said 5 to 7% all in. So we're not really talking about, you know, great strides, and obviously for those who are interested, there's more work to do. So
Right.
on that work to do, Dina, you know, what do we do now? If I am an institution, what should I be thinking about?
Yeah, and I'm a big proponent of talking about action. You know, a lot of people will say, this is all well and good, but what can I do? And I sort of think about this as everyone can do something. I think the candidates, you know, if you're a diverse candidate, I think there's more that you can do. I have been a board candidate, so I can tell you from some of my own lessons learned. I think sitting on the board, I think there are different actions that the board can consider taking. And then, you know, certainly in financial services, the management group, how are they attracting and retaining diverse people? How are they bringing them up through the ranks and getting them the skills, experience, qualification to ultimately serve on boards at some point in their career? So I do think there's a lot of different places. Starting with the candidates themselves, we talked about that concept of self-identification. You know, certainly when I was growing up, if you will, I never included that type of personal information about myself in a bio, in a resume, in an email. I never called it out. In fact, I was probably one of the people who tried to neutralize everything, you know, just sort of compete on you know, the basis of the words on the paper.
So that's a good point. Let me stop you right there. Our questions come in from someone who's asking about individual efforts to join some of these boards, and it says, how does someone become a board member? I've been a Mexican hedge fund manager for over 15 years, been in business for about 20, and there are no opportunities. I hear about diversification, but all I see is no's and roadblocks by all the major firms. So what are your thoughts on that?
So, you know, I will tell you, especially to this particular listener, it takes time. You know, for me, it took a good 2 years of concerted effort to get myself into the interview circles. And it's not necessarily comfortable. There's a degree of self-promotion. There's a degree of networking. Talking to law firms such as Thompson, Hine, they tend to know of the openings before others do. Accounting firms, the independent auditors tend to be trusted advisors that know of the openings. So we could do an entire coffee chat just on how to get on a board. But I will tell you anecdotally, and I shared this with Mark, in the last few weeks, individuals have reached out to me as part of my networking effort and said, gosh, we don't know diverse candidates. Can you help us meet people? And I said, give me a couple days and I can send you 12, 15, 20 resumes in a single shot of diverse candidates. Diverse candidates are out there. There just needs to be more connectivity to the people looking for them. So I understand this particular listener's plight because I've been there. I personally am working to change that. But as a candidate, there are definitely efforts that you can take to get yourself in the mix. And then I also call on anyone who's sitting on a board or who's sitting in management to start thinking about efforts that they can take from their more institutional places. Because there are opportunities. It is just a matter of connecting the candidate to the circle.
So with the last few minutes that we have, you and I had some conversations about what boards could do or what management of companies could do to specifically address this. And some have who are really putting their money where their mouth is to show commitment in this area, are doing some really interesting and innovative things. Could you share some of those?
Sure. Yeah, one that I was telling you about, Mark, is a large company decided that DEI really was part of their strategy. It wasn't just something to check off their box. They have 35,000 associates, and they rolled out a year-long program that every other month, all associates were going to be in a 2-hour breakout session focusing on DEI conversations. The breakouts were from 6 to 40 individuals, and then they were assigned accountability partners to keep the conversation going. And to me, this is a real investment at the corporate level of, not just saying, okay, you have a 1-hour diversity training and then that's it for the year. This is a real investment of time and resources. I think there's a lot of things that companies can do. And I think it's on all of us to sort of embrace those opportunities. Again, I think the boards at the board table should be talking to management about the strategic initiatives of diversity, equity, and inclusion, and making sure, in my mind, that those are embedded in the strategy and not just the 5th bullet point of, tagging along with 4 other strategies.
Well, Dina, unfortunately, that time went back like a bullet. And we probably could do a whole presentation on how to position yourself for consideration by boards. But for now, I think we're going to have to leave it there. My thanks to Dina Tantra. Thompson Hine, shares your passion for this issue. She's an expert at managing and helping her clients and institutions through this labyrinth of the new rule. And I encourage you to seek expert advice if you're dealing with it. And so that concludes our chat for today.
And Mark, I'll just say for your listeners, feel free to reach out to me from LinkedIn, reference this event, and I'm happy to have that conversation.
Well, we're certainly going to post that. Our next coffee chat, for those listening in, will be November 17th. Philip Sinning and I will be discussing excessive fee cases, best practices, and lessons learned. If you missed this or if you miss any prior coffee chat, we encourage you to view our library of recordings. And we want to thank you for attending today's program. Thanks, Nina.
Great. Thank you. Thanks, Mark.
Thanks. And fill out your surveys. Take care.